Good morning everyone. I will welcome you all to the 13th group presentation competition of Chinmay Tutorials. As you all are in CS professional and very soon you all are going to be company secretary. And you are going to be appointed as company secretary in MNCs and big firms or any other listed companies. So here your designation is very high and the expectations of the company is also very high obviously. So they demand a complete professional person who is not only good in legal but also good in presentation as well. In the year 2015, just before that, we had a lot of issues. Like students who have cleared their exam in first attempt were not able to crack their interview even in training for MNCs and listed companies. This was the biggest issue which we realized we must work on that. So since 2015 till the date we are organizing this group presentation competition. This respective competition is not going to increase or groom up your communication skill, but also it is going to develop your coordination skills as well as your presentational skills. I hope this respective presentation will at least groom 10 to 20% personality of you people, and we got a good response from all the students in last years also. So we decided that this must be the part of our curricula. So in every attempt we organize such kind of activity. So this is our 13th group presentation competition, and this respective competition of yours is going to be examined and judged by none other than CS Chinmay Jain sir, who is going to mark you, evaluate you and judge you on various grounds like your attire, your communication skill, your coordination, your presentation, your confidence. Each and everything is going to be examined over here. So I hope you all are ready. Yeah. So now I would like to invite teams one by one on the stage. So Chinmay sir, please announce a team which is going to present their performance. Team number? The team 2 come on the stage. Have a big round of applause for the team 2.
A very good morning to one and all present here. I, Bhavya Lakhotia, along with my teammates Akshita Sharma, Deepansh Srivastav and Mitali Agarwal would be presenting on the top. Is its subject matter, that is property. An ordinary person might not have heard or used the words arbitration or foreign exchange in their daily lives, but property is one such word that almost every ordinary person has used in their daily lives, irrespective of the fact whether such person possesses any property or not. So, for us being in this professional stream as well as for those ordinary individuals, it is very much important to learn about the law which governs the transfer of property. As Mark Twain has said, the secret of getting ahead is getting started. So, without much further ado, let us start with the presentation. Now, property has always been one of the most fundamental elements of an individual's socio-economic life. Also, Universal Declaration of Human Rights also recognizes the right to own property. Article 17 of UDHR provides that everyone has the right to own property alone as well as in association with other persons, and that no one shall be arbitrarily deprived of this right. Also, Article 300A of our Constitution provides that no person shall be deprived of his right to property except by the authority of law. Moving ahead, we will talk about the objective of the Act. This Act was basically enacted with the object to amend the law relating to the transfer of property by the Act of Parties. As it can be clearly seen from this objective that this Act is not an exhaustive legislation, as the preamble as well as the object does not include the word consolidate, which means that this Act only applies to a certain kind of transfers and a certain kind of property which will be dealt earlier in the presentation. Moving on, let us talk about the scheme or structure of the Act. Now, transfer can be effected by two ways, which is by either transfer can be made by the Act of Parties or it can take effect by operation of law. When I say by operation of law, it means that here the law mandates that a property shall be transferred and the law governs how such property shall be transferred. For example, if a person has become insolvent, so here in this case, the law and the court will decide as to how this property will be distributed, in what manner and to whom. Whereas when we talk about transfer of property by act of parties, it can take place either in form of testamentary or inter vivos. When we talk about testamentary, it states that testamentary is basically a will. It states that the transfer shall take effect after the death of the person. The same is not covered under the ambit of this act. It is covered under Indian Succession Act. But when we talk about inter vivos transfers, it means the transfers that take place between living persons. So these inter vivos transfers are covered under the ambit of Transfer of Property Act. Moving ahead, now inter vivos transfers, under inter vivos transfer, the property transferred can be either movable property or immovable property. So under this act, only transfers relating to immovable property is covered, as well as some special transfers which are sale, mortgages and charges, leases, exchanges, gifts, as well as actionable claims. Moving ahead, now a question might arise in your minds whether property is a single right or a bundle of rights. So when I say that a property is a single right, it basically means that the property as a single right, it means that it provides the owner the right of exclusion, which means it gives the owner the right to exclude others from his enjoyment of the property. But in actuality, property is a bundle of rights, which includes the right of the owner to dispose of the property as he deems fit. Second, the right of the owner to enjoy the property as he deems fit. Third is exclusion, which means that it is the right of the owner to exclude others from the enjoyment of his property. For example, an owner may prevent some other person to trespass upon his property. Fourth is that an owner has the right to possess the property. And last is an owner has the right of control over the property as he may deem fit. Now, moving ahead, we will discuss about some of the essential elements of transfer of property. Basically, there should be a transfer of property by one person who does not have any title over it to another person who has the title over it. The transfer shall take place between two living persons. Third is conveyance. Conveyance is simply an act by which a property is transferred between living persons. Fourth is property. This word is quite self-explanatory, but this term property has not been defined under the Act. However, Section 9 of the Act provides that a property of any description may be transferred. So, this Act has given the term property a very wide sense, and also it has been left for judicial interpretation. Last is that a property can be transferred either in present or in future, but the property must be in existence. Moving ahead, we'll discuss some kinds of property. Property has been divided into two types, that is jus in re propria, which means the right of a person in his own property, and jus in re aliena, which means the right of a property in other things. When we talk about jus in re propria, it contains either material or immaterial property. When we talk about material property, it includes land and chattel, which can also be termed as corporeal property. However, when we talk about the right of a person, when we talk about immaterial property, it includes patent, copyright, trademark, which forms a part of incorporeal property. Now, when a person has a right in other things, it includes servitude, lease, mortgage and securities, which also forms part of incorporeal property. Moving ahead, we'll talk about the classification of property. As we all know that property has been classified into two types, that is movable property and immovable property. Now this Act does not define the term movable property, but as per General Clauses Act 1897, movable property has been defined as any property, as a property of any description which is not an immovable property. So what exactly is immovable property? The Act also does not define what is an immovable property. So, General Clauses Act gives an inclusive definition as to what is an immovable property. It states that immovable property includes land, the benefits that arise out of land, things that are attached to earth or forming part of the earth, but which excludes standing timber, growing crops and grass. Moving ahead, we'll talk about formalities of a transfer, which will be
formalities of transfer. Formalities of transfer start with attestation, followed by registration and ends with service of notice. Now, attestation. Attestation means authentication or verification of signature of executant of documents. Its essential features are: first, there must be at least 2 or more witnesses. Second, each witness must see executant sign. And lastly, each witness must sign the instrument in the presence of executant. Attestation must be compulsory. However, not all the transfer required attestation compulsorily. For example, in case of sale deed or lease deed, attestation are not compulsorily required, but in case of mortgage deed and gift deed, attestation is compulsorily required. Now, moving on to second formalities, which is registration. As we all know that registration is very essential legal formality. Registration in movable property is optional, but registration in immovable property of value of more than 100 rupees are compulsory. The main advantage of registration is it gets legal benefit and serve as an evidence in the court of law. Now, moving on to the last formality, which is notice. Knowledge of fact is notice. Notice is, there are 2 types of notice. First, actual notice, and second, constructive notice. In actual notice, if a person knows about the fact, it is known as actual notice, but where law presumes that the person might know about the fact irrespective of the fact that he knows about it or not, it is known as constructive notice. Now, moving on to very important section, which is section 6, which talks about property which cannot be transferred. As we all know, this is a general rule that property of every description can be transferred, but section 6 is exception of the general rule. Now, first, spes successionis or chance of heir apparent. It means chance to be heir apparent. A person can transfer his property only if he is the owner of the property or he is authorized to transfer the property. But in this, transfer is done by a person who has mere only hope or expectations to get the property, and it is absolutely void. Let us take example. For example, if a son transfer his father's property in only a hope and expectation that he is going to get the property, as he is the only son of his parents, now this transfer is absolutely void, although spes succession is exception of doctrine of Estoppel. Now, moving on to next exception, which is right of reentry. This is right which the lessor has in the case of lease. When in the case of breach of contract, only the lessor has right to re-entry in his property and right to repossess his land from the lessee. This right of re-entry is not transferable. Now, the third exception is restricting interest or personal interest. For it has 2 examples, like right of possession or right of preemption and right of widow to live in her marital house. It is absolutely a personal interest and hence not transferable. Fourth exception is transfer of easement. Easement is a right enjoyed by the owner on the land of other. Easement includes right of way, right of light, flow of air. This is right of land. For example, let us take example. This is very relatable concept. We can see its example in our day-to-day life as well. As the person residing in the apartments or society can relate to me about this concept. In societies or apartment, common terraces, common swimming pools, common clubs, playground, parks, etc. These rights can only be enjoyed by the person residing in the society and having flat or apartment in the society. These rights cannot be transferred. Fifth, right of future maintenance. This is again a personal right. It includes right of Hindu widow or divorcee to maintenance. It is a personal right. However, the right of past maintenance can be transferred, but the right of future maintenance cannot be transferred. Sixth, mere right to sue. A right to sue cannot be transferred. This prohibition is based on the public policy. Moving now, next exception, a public office cannot be transferred, nor the salary for the public officer. Next, stipends allowed to military, air force, naval, etc. are also not transferable. Now, moving further, we will talk about next section, which is section 10, which talks about restraint on transfer or rule against inalienability. Next, section 11, which talks about restraint on enjoyment, and last, section 12, transferee being insolvent. Section 10, rule against inalienability. Alienability means power to transfer, whereas inalienability means restriction on power to transfer. This section states that when a person transfers his property, the transfer cannot impose or restrain absolutely the transferee from further transfer. As we all know that, for example, let us take example, Mr. A transfer his property to Mr. B, adding a condition that if Mr. B further transfer the property, then the property will revert back to Mr. A. Then this condition is absolutely void and transferee can ignore such condition. In this case, the transfer is valid, but the condition imposed by the transferor is absolutely void. However, partial restraint are considered as valid in family settlement. Like for example, condition such as not to alienate the property outside the family is absolutely valid. Exception of absolute restraint are: first, lesser impose condition on lessee that he should not sublease the property, then this is valid. And second, when the transferee is married woman who is not Hindu, Muslim, Buddhism, condition that he will not transfer the property that during the marriage is valid. Then these two are exception of the section 10. Now let us move to section 11, which talks about restraint on enjoyment. In section 10, we discussed about restraint on transfer, but here we discuss about restraint on enjoyment. When a person transfers a property to another person by imposing a condition so that transferor cannot enjoy the property as per his own wishes, then this is absolutely void. In this case, both condition and transfer both are void. But exception of this case is if a person transfers one of the two adjacent property and puts a condition that not to construct another floor to protect his right to light and free air, then this is absolutely permissible. In that case, both condition and transfer both are valid. Now further sections are dealt by Akshita.
Moving on further, we will talk about section 12, which states that transferee being insolvent. When a person transfers a property and puts a condition that the property will revert back to him if transferee becomes insolvent, then such condition and the transfer both will be considered as void. But there is an exception to it, which says that if this condition is imposed by lesser, then such condition and the transfer both will be treated as void. Moving forward, we will talk about the transfer for the benefit of unborn person. In general, transfer of property act covers inter vivus transfer, which is the transfer between two living persons. But there is an exception to it, which is section 13. Section 13 states that a transfer can be transfer of property can be transferred for the benefit of unborn person. But who is an unborn person? Unborn person means a person who is not in existence or who has not been conceived yet. But you all might be thinking how a property can be transferred to a person who has not been born, who has not been in existence. So answer to this question is given in section number 13, which states that a property can be transferred to an unborn person, but two conditions must be complied. The first one being it should be preceded by a life estate in favor of a living person. That means that a prior interest must be created for the benefit of unborn person. Second being, it should comprise whole of the remaining interest of the transferor so that there can be no further interest in favor of the other. It means that the unbound person must be the absolute owner of the property. Moving on further, we will talk about prerequisites of transfer for the benefit of unbound person. Firstly, there can be no direct transfer. If a property is to be transferred to unbound person, then it should be indirectly transferred. The second being, existence of an unborn child is important. That is, the unborn child must come into existence before the death of the last life estate holder. And the third being, prior interest. Some life interest must be enjoyed by some other person before the birth, before like unborn person comes into existence. The next being, as soon as the unborn child comes into existence, or the vested interest must be enjoyed by such unborn person. Lastly being, he must be the absolute interest holder. It is important to note here that unborn person must be the absolute owner. Life interest cannot be transferred to such unborn person. Let's understand this with an example. So here, a person A is transferring a property to B with the condition that after B's death, the property will be transferred to C, followed by D, and finally to S. So what makes this transfer a valid transfer is the absolute interest. Here, absolute interest is transferred in favor of B, in favor of S. But as we can see in the second example, that A is transferring a property to B, with the condition that the property will be transferred to C after B's death, followed by D, and then to S. But here, life interest has been transferred, which means that the property will revert back to A after D's death. So moving on further, we will talk about rule against perpetuity. Section 14 talks about rule against perpetuity. Perpetuity means forever, that is indefinite period. That is indefinite period. So as a normal person who is owner of a property thinks that my generation should use my property. So for example, if A is the owner of a property, he would like that his son should enjoy the property, and then further to his son, and so on. Here, property is being transferred from generation to generation, but this is not allowed as per section 14. It states that the property can be transferred for limited period subject to the condition that all the life interest holder must be living on the date of transfer. Absolute interest holder must be born before the death of the last life estate holder, and the transferability can be postponed up to the minority of the absolute interest holder. With this, let's see the essentials of section 14. There must be a transfer of property, and the ultimate benefit must be enjoyed by the unborn person, and the vesting of interest, which is the prior interest, must be created in this section. Then moving further, ultimate beneficiary, that is the absolute owner, must come into existence before the death of the last living person. And finally, the maximum period for which the property can be transferred is life of living person and minority of the ultimate beneficiary. With this, we will move forward with some exceptions of section 14, which is stated under section 18. It states that where transferability of property is postponed for perpetual period to promote religion, health, art, commerce, knowledge, or anything beneficial to mankind, then in all these cases section 14 will not apply and they will be treated as valid. Moving further, we will talk about section number 25, which is conditional transfer, where when a property is transferred subject to some condition, that it is called conditional transfer. Such a transfer may be subject to condition precedent or condition subsequent. But what is condition precedent? If the interest is made to accrue on the fulfillment of the condition, then such is a condition precedent. For instance, if A agrees to sell a land to B on a condition that B marries C. So in this case, if B marries C, then he will get the property. This is condition precedent. Now, there are some requirements of condition of transfer, condition precedent, which are: the condition must not be forbidden by law. The next being, the condition must not be impossible and it should not be fraudulent. The condition should not be immoral or opposed to public policy, and the nature of the condition should not be such that if permitted, it would defeat the provisions of the law. Moving further, we will talk about condition subsequent. When a condition is when some condition is imposed and the condition on the fulfillment when a condition is imposed, the condition subsequent is one which destroys or
which destroys or divests the rights upon happening or non-happening of an event. For instance, A agrees to transfer a farm to B with the condition that if B cuts the wood, the transfer shall cease. If in case B cuts down the wood, then he loses life interest in the property. With this, let's see some difference between condition precedent and condition subsequent. First being, fulfillment of condition precedent completes title, interest and transfer, whereas fulfillment of condition subsequent extinguishes a title, interest or a transfer. And condition precedent always comes before the transfer of property, whereas condition subsequent always follow the vesting of an interest which is already in existence. The next being, the vesting is postponed in case of condition precedent, vesting is postponed till the completion of condition, and whereas in condition subsequent vesting is immediate. The next being, interest once vested cannot be divested in condition precedent, but in case of condition precedent, interest is liable to be divested on non-fulfillment of the condition. Lastly being, acquisition of property depends on condition precedent, whereas retention of property depends on condition subsequent. Now we will move to doctrines which will be held by, which will be taken by
We will talk about the following doctrines. First being Doctrine of Election, which is covered under section 35. Second is Doctrine of Holding Out, which is covered under section 41. Doctrine of Estoppel under section 43. Doctrine of Lease Pendants under section 52. Doctrine of Fraudulent Transfer under section 53, and Doctrine of Part Performance, which is covered under section 53A. Now let's talk about all of these doctrines individually. Firstly is Doctrine of Election. The basic principle or foundation of this doctrine is that where a person is deriving a benefit under one instrument, he must also bear the burden which is present under the same instrument. So basically it talks about that the benefit and a burden must coexist. Let us understand this better with the help of an example. For example, if Mr. A transfers his paddy field to Mr. B on a condition that the paddy field will only be transferred to Mr. B if Mr. B transfers his house in favor of C. Now what is happening in this scenario is that both the benefit and burden are coexisting. So Mr. B must now elect that if he wants to take up the instrument, in that case he will have to bear the burden. That is, if he wants the paddy field, he will have to transfer the house in favor of Mr. C. Or he can choose to go against the instrument, in which case he will neither get the benefit nor will he have to bear the burden. Like if he chooses to go against the instrument, he will not get the paddy field, and also he will not have to transfer his house to Mr. C. Moving on to the next doctrine, it talks about Doctrine of Holding Out, which is also known as transfer by ostensible owner. Now who exactly is an ostensible owner? Ostensible owner is a fake owner, any person who appears to have a right who appears to the general public that he has the right or title to the property, but in fact he is not the real owner of the property. Now let us understand this doctrine with the help of an example. Suppose if Mr. Person A, who is the actual owner of the property, authorizes Mr. B to be the fake or ostensible owner. Now Mr. B transfers a property in favor of an innocent buyer for a consideration. Now what happens is Mr. A comes and he says to the innocent buyer that Mr. B was a fake owner and that he did not have any authority to effectuate that transfer. Now what exactly will happen in this situation, whether the property will be transferred or not? So this doctrine clears out the doubt that it says that if any person is a fake owner or an ostensible owner and he transfers the property for a consideration in favor of another person, which under the express or implied authorization or consent of the real owner, then such transfer shall not be voidable on the ground that the transferor did not have any authority to make the transfer. Moving on to the essential conditions which are necessary in order for this doctrine to apply. Firstly, the transferor must be an ostensible owner, that is a fake owner. Second, basically the real owner must have provided the authority or consent for him to act as the fake owner. Third is the transfer must be for a consideration for this doctrine to apply. And the last is that the transferee to whom the property is being transferred must have acted in good faith, taking all the reasonable care that the transferor who has transferred the property had the actual authority or power to effectuate that transfer. Now, if any of the conditions or elements are missing, then the transferee will not get the protection under this doctrine. Also, this doctrine is the exception to the very rule that a person cannot confer a better title than he has, because here in this case a fake or an ostensible owner is transferring the property. Moving on to the next doctrine, which is the doctrine of feeding the grant by estoppel. Now, basically in this doctrine, a transfer of, for example, a transfer of some immovable property has been made to a person for a consideration, for a consideration, and the transferor fraudulently represents that he had the authority to make the transfer of all of such properties. So, in this case, what will happen? The transfer will be considered valid only if at a later period or at a subsequent period the transferor actually acquires the interest in such property. However, this doctrine shall not impair the right of a transferee who had acted in good faith and who had paid the exact amount of consideration as was demanded. Now, let us understand this with the help of an example. For example, Mr. A, who was separated from his father, Mr. B, at the time of the property was partitioned. So, if Mr. A suppose sells 3 properties X, Y, Z to Mr. C, representing that he had the authority to make the transfer of all of these 3 respective properties. But however, the property Z did not actually belong to A. He was only fraudulently representing that he had the authority over all of the properties. This property Z was retained by his father, Mr. B, at the time of partition. So, in this case, but what happens is, the father, Mr. B, dies. So, being an heir of Mr. B, eventually he will get the interest in property Z being his heir. So, in this case, if the contract has not been rescinded by the third party, that is Mr. C, then Mr. C may require that Mr. A shall deliver such property to him, because he has subsequently acquired the interest in such property. Moving ahead, let us talk about the doctrine of fraudulent transfer. The basic crux of this doctrine is that when a property is transferred to any third person in order to defeat the rights or the interest of or any valid interest of any third party in the property, then such transfer is called as fraudulent transfer. For example, if a debtor transfers his property to any of his friends or relatives in order to defeat or delay the claim of creditors, then such a transfer shall be voidable at the option of the creditor whose rights have been defeated or delayed. Moving on to the next doctrine, which is doctrine of part performance. Now, this doctrine basically provides protection, or it has basically been introduced for the benefit of tenants. What used to happen was, for example, if a builder has transferred an apartment or a building or any immovable property in favor of another person, that is tenant. So, for a consideration, the possession has been transferred to the transferee, and also the transferee has paid the consideration. But later on, he comes and contends that just because the registration has not been effected yet, that the tenant is merely trespassing on his property. So, in order to avoid such problems, this doctrine was introduced. Some of the major essentials of this doctrine are that there must be a contract to transfer immovable property. That means an immovable property must be transferred under the contract. Second is, the property must be transferred for a consideration. Third, the contract should be in writing and must be signed by the transferor or any other person on behalf of the transferor. Fourth is that the terms which are necessary to constitute such transfer must be ascertainable with the reasonable certainty reading the contract itself. Fifth is that the transferee should have taken the possession of the property in the part performance of the contract. And last, that the transferee must have fulfilled or is ready to fulfill his part of the obligations under the contract. Now, moving on to the last doctrine, which is Doctrine of Lease Pendants, which is covered under section 52. Doctrine of Lease Pendants merely states that nothing new can be added during the pendency of a suit. It merely suggests that if there is a dispute over the title of a property between two parties, then none of the party can transfer such disputed title property to any third person so as to create multiple rights in such property. The basic elements of this doctrine is that firstly, a suit must have been pending. Secondly, the subject matter of such suit should be an immovable property. Thirdly, any party to suit should have transferred the property in favor of any third person. Fourthly, that the transferee takes the property according to the decree of the court. And lastly, the suit must not be a vicious one or a fraudulent one. Moving ahead, we will talk about some special transfers of immovable property which will be presented by Deepansh.
Now we'll go further into the Act and talk about some special transfers of immovable property. These are sale, mortgage, exchange, lease, gift and actionable claims. Let's talk about each of them individually. First we have is sale. Under section 54, sale is defined as a transfer of ownership of property for a consideration which is paid or partly paid or promised. There are some essentials of sale which can be transfer of ownership. A subject matter of sale is an immovable property. Consideration must be in money and a price should be paid. Sale can be made by two modes, that is by registered instrument and second by delivery of possession. The difference between the two is of just ₹100. Yes, thus ₹100. If a property is of value of property is more than ₹100, then it can be only transferred by registered instrument. But if the value of property is less than ₹100, then it can be mainly transferred by the transfer of possession. Let's talk about the next special transfer, which is mortgage. Mortgage is transfer of interest in an immovable property from one person to another for a security of money. There are many types of mortgage. First is simple mortgage. In simple mortgage, the mortgager binds himself to the mortgagee to pay the loan. If he fails to pay the loan, then the property can be sold by the mortgagee to satisfy his debts. Next we have is conditional sale. If a mortgager fails to repay the debt, then the mortgagee has right to transfer the property in his own name. And if he pays the property, then the property will be retransferred to the mortgager. Next we have usufructory mortgage. The word usufruct means using the property of someone else. In this, the mortgager would deliver the possession to the mortgagee. So the mortgagee enjoy the right of the property of the mortgager. So he can collect the rent and profit accrued from the property, and he can use this in lieu of a principal or interest. Next we have in English transfer. In English transfer, the property is absolutely delivered to the mortgagee, and the ownership of the property is also transferred to the mortgagee. When the loan is fully satisfied, the property is retransferred to the mortgager and the ownership also transferred with him. Next we have is mortgage by deposit of title deed. As it's a very common example of this is home loans. Everyone have heard about home loans. What we do is we purchase a house by home loan and deliver our title deed to the bankers. They have the title deeds and they give it us back when the home loan is paid in full. And if any mortgage doesn't come under any of these mortgages, then it will be covered in the last one, that is anomalous mortgage. Next there are some special. Next we will talk about sub-mortgage and puny mortgage. Let's understand both of these mortgages with the help of an example. Let's suppose there is a person, Mr. A, and he have a property of ₹50,000. He mortgages the same property to Mr. B for ₹20,000. Now Mr. B mortgages the same property of Mr. A to Mr. C. Now this transaction between Mr. B and C is called sub-mortgage. Now if in the same example, A himself mortgages the same property to Mr. B and Mr. C individually, then that will be covered under the puny mortgage. Next we have some provisions related to the mortgage. The first is priority of debt of mortgage. It simply means that the mortgage which is firstly charged on the property has to be dealt first, then the subsequent one. If in case of fraudulent or misrepresentation, then the subsequent can be charged before the first one. Next we have is marshalling by the subsequent owner. Let's understand marshalling by the subsequent owner with the help of an example. Let's suppose there is a property owner named O. He has 3 properties, property 1, 2 and 3. He mortgaged all 3 properties to Mr. M, and if he to Mr. M for rupees 30,000. But he needs more money, so he mortgages the property 1 again to Mr. B. So now Mr. B has a right to compel Mr. M to satisfy his debt from his property 2nd and 3rd firstly, because the property 1 is also mortgaged with him. This concludes us with the mortgages. Now let's go to next, that is charge. Now charge is where the interest on a property is created for a loan, and which is not covered under the mortgage. The charge can be made by two ways, that is by act of a party or by operation of law. In act of the parties, debtor and creditor voluntarily make the charge on the debtor's property, and in operation of law, the judiciary makes the charge on the property of the debtor. There are 2 types of charge. First is fixed charge and second is floating charge. Fixed charge is a charge which is made on fixed assets, and floating charge is a charge which is made on the floating assets. Next we have is exchange. Exchange is when 2 persons mutually transfer the ownership of a property in return for the transfer of ownership of another property, and none of this property is a money. There are few essentials of the exchange. These are: person making the exchange must be competent to contract. Second, there must be a mutual consent. Third, there is a mutual transfer of ownership. Fourth, there is no money consideration. Next we have is lease. Lease is transfer of right to enjoy immovable property. Its essentials are: first, transfer of right to enjoy property as it is covered in the definition. Second, it is made for a consideration, and here consideration can be known as premium or rent. Third, that the transfer is for a certain time or perpetuity, and fourth, the transfer must be accepted by the transferee. There are different type of tenancies. First, tenancy from year to year. Second, tenancy at will, and third, tenancy by sufferance. Tenancy from year to year is when there is a contract between the tenant and the landlord for a year, and after the completion of 1 year, the landlord still possesses the property and pays the rent. Then it will be covered in tenancy from year to year. Second is tenancy at will. In tenancy at will, the property is possessed by the tenant under the will of landlord and the tenant both. And when the property is possessed by the tenant without the consent of the landlord, then it will be covered under property by sufferance. Next, how can a lease can be determined? Means how can a lease can come into end? It can be come into end by way of efflux or lapse of time, by happening of a special event, by surrender, by default feature, or by merger. There is a difference between lease and license. Let's look at them. The first is that lease is a transfer of interest, whereas license is just a personal right. Second, a lease is served with a notice a lessee is served with a notice before the quit or eviction, but a licensee is not entitled to get such notice. Third, a lease is both transferable and heritable. Licensee is neither transferable nor heritable. Fourth, a lease is unaffected by the transfer of property. That is, if a property is being sold, then also the lessee has the right to have the property under his possession. But whereas in case of license, if a property is sold, then a licensee has no rights under it. And last, the lease is non-revocable and the license is revocable. Let's go back to the next. Before going back to the next transfer, let me ask you a question. How many of you like gifts? I think everyone will do, and so does our government. So they have added this in the special transfer. So what is gift? Gift is a transfer of movable or immovable property by a person named donor to another person named donee, not for a consideration. That is, there is no consideration in this, and it is accepted by the donee. There are few essentials of the gifts, which are: transfer of ownership, property must be in existence, there should be a voluntary transfer, without consideration and accepted by the donor. In a very famous case law of Kalyan Sundaram Pillai versus Karoppa Moparam, it was held that gift once accepted cannot be revoked, and mere pendency of registration is not a ground of revocation. There are few terms which is related to gifts. First is suspension or revocation of gift. A gift can be revoked or suspended only by agreement or rescission. Second, conditional gift. A gift can be made on a conditional basis, that is, on a fulfillment of a special condition, only the gift will be transferred. Third, by a universal donee. When a donee gets all the properties of the donor, it's called a universal donee. And last is onerous gift. When a gift is transferred to the donee with a burden on the donee, then it is called as onerous donee. Next we have is actionable claims, which is also a last special transfer. So, which actionable claims means any claims to any unsecured debt. It has many examples, such as a claim for recovery of arrears of rent, a claim for provident fund which has been due, a claim of life insurance policy which is matured. With this, I would like to end our presentation with a very famous English proverb, which is, all good things shall come to end, and so our presentation. Thank you.
After this outstanding performance of Team 2, now I would like to invite next team, team number 1 on this stage. Have a big round of applause for team 1.
A very good morning everyone. I am Ronak, and today me, Arohi, Aishwarya, Isha and Saloni will be giving a presentation on the topic arbitration. As we know that the population of India is over 130 crores, and we cannot even imagine how many disputes are arising every single day. Not all these disputes can reach court, and even if they do, it can be really time consuming and costly. So instead, parties can opt for an alternate dispute resolution called arbitration for the purpose of solving their dispute. So what is arbitration? It is a method of solving civil disputes between two or more parties through an intervention of an independent and impartial third person called arbitrator. So these two people are in dispute with each other, but instead of going to the court, they go to an arbitrator to solve their dispute. But why did they choose arbitration over litigation? The answer is, it is flexible. It is flexible in the sense that the parties are free to determine the manner, language and place of arbitration and whom they want to appoint as the arbitrator. And the second advantage is it provides a quick process. Court proceedings can be really time consuming, and I think we all are very well aware of the phrase Tariq pe Tariq, Tariq pe Tariq. So to avoid that, parties can opt for arbitration for quick settlement of their dispute. The next advantage is it provides quality justice, as it is the parties who appoint the arbitrator, and they usually appoint a person who has the knowledge and experience about the subject matter of the agreement. This enables quality justice. And next is quick decision, as the whole arbitration process is a time bound process, so it is a duty of the arbitrator to give his decision within such time period. And in last but not least, it is cost effective. The fact that the arbitration can be done by a single person and the arbitrator's fees can be substantially less than the court fees and the lawyer's fees combined, we can say that it is cost effective. And also, as we have discussed earlier, that arbitration saves time, and it is very well said that time is equal to money. We can still conclude that arbitration is cost effective. So how the parties enter into an arbitration? They enter into an arbitration through an arbitration agreement. It can be in the form of an arbitration clause, which means that it is a part of any separate agreement, which can be a partnership deed or any other contract as shown in the illustration 1, or it can be a separate independent agreement as shown in the illustration 2. So what are the requirements of an arbitration agreement? It must be in writing. An oral agreement cannot be an arbitration agreement like this one. No specific format is required for arbitration. It is the parties are free to determine the manner of the arbitration, and it must refer to a dispute present or future. Usually an arbitration clause refers to a dispute which may arise in the future, whereas parties make an independent arbitration agreement when the dispute has already arisen. Further, my teammate Arohi will continue.
Thank you, Ronak. Now let's understand the meaning of arbitration and arbitration agreement from this video. Here it is.
In this video, we will discuss arbitration. Arbitration is a system of private justice, not a court proceeding. Let's say that Patty and David have a contract. Patty thinks that David broke the contract, and David says that Patty broke the contract. Patty and David could go to court, of course, but let's say they don't want a public court proceeding. Do they have any other option? They could ask another person, Alan, to decide who is right. Alan could act as a private judge. In his role as a private judge, Alan is an arbitrator. If Patty and David select Alan, they have an arbitration agreement. Patty and David have now rejected going to court. Instead of going to court, Patty and David meet at Alan's office.
In this video, we can see that both the parties refer their dispute to arbitration instead of moving to the court. Now, let's move to the next topic, which is types of arbitration. Types of arbitration is based on two types. First is jurisdiction and second is procedure and rules. Further, basis on jurisdiction, it is divided into three types. First is domestic arbitration. In this, both the parties are Indian of arbitration agreement. Now, second one is international arbitration. In this, one party is Indian and other party is from outside India. Now, third one is international commercial arbitration. It is just like international arbitration, but the difference is it arises out of commercial contractual obligation. Now, on the basis of procedure and rule, it is also divided further into three parts. First is institutional arbitration. In this, arbitration is conducted by arbitral institution. And second is ad hoc arbitration. In this, parties arrange arbitrator themselves. And third one is fast track arbitration. In this, arbitrator abandons all methods which are time consuming. Now, if there is agreement between two parties, then if their dispute arises, then they shall move to the arbitrator for solving their dispute. What if a party go to the court instead of going to the arbitrator? Then judicial authority may refer their case to an arbitration, but on the such following condition. And the first condition is if there is valid and enforceable arbitration agreement. Second is subject matter must be within scope of agreement. Third is the application must be made by the parties. And fourth one is application must be made at earlier stage of proceeding. If other party doesn't do so, then court will consider there was no agreement between and will accept the suit of the party. And fifth one is application. If the other party wants to prove that there was an agreement between the parties, then the other party have to submit arbitration agreement or certified copy of that agreement to the court. Now, there are some matters which we can refer to the arbitration, and there are some matters which we can't refer to the arbitration. In this, first we will discuss about which can be referred to arbitration. The first one is determination of damage, question of validity of marriage, matters of right to office, time barred claims. Court doesn't accept time barred claims, but both the party want to settle their dispute, then they can move to the court for solving their dispute. And now we will discuss about there are some matters which we can't refer to the arbitration. In this, first one is validity of will, divorce, insolvency, lunacy proceedings, criminal matters, guardianship of minor, and unless and other specified in Arbitration and Conciliation Act 1996. From this further Aishwarya will continue. Thank you.
Thanks, Aruhi. Now the next topic is Arbitral Tribunal. Tribunal shall have the same power as of a civil court under Code of Civil Procedure. First of all, we have to understand that what is tribunal. Just like court, tribunal have the same power. Now, about what is arbitral tribunal? Arbitral tribunal refers to a panel of one or more arbitrators responsible for adjudicating dispute between the parties. Basically, one or more arbitrator together called as arbitral tribunal for resolving the dispute between the parties. Now, the next topic is number of arbitrators. That for any arbitral proceeding, arbitrator is very important. So, what should be the number of arbitrators that a party shall appoint for their dispute? Let's see, parties are free to decide. It means parties are free to decide any number of person as their arbitrator for their dispute, but it have one condition, that it should not be in an even number. That the arbitrator should not be in even number. It's only and only in the form of odd number, just like 1, 3, 5, 7 and so on. What if parties fail to determine, then there shall be a sole arbitrator. If parties not decided that what should be the number of arbitrator, then in that case only sole arbitrator will appoint. It means only individual or single arbitrator. The next topic is appointment of arbitrator. As we know, arbitrator is important in any arbitral proceeding. So on which basis the appointment of arbitrator will shall conduct? So in that, the person of any nationality, person of any nation can appoint as an arbitrator. It's not necessary that arbitrator should be an Indian one. If a party belongs to the different nation, that in that case arbitrator will be an Indian one, or maybe it can be a foreign one. If parties agreed to appoint 3 arbitrators but don't agree on procedure of appointment, in some situation parties don't agree that on which basis they have to appoint that 3 arbitrators. So in that case the party shall appoint one each, and those 2 arbitrators combinedly shall appoint the third one. Now suppose if parties fail to appoint the arbitrator within 30 days, so in that case the Supreme Court and High Court shall have the authority to appoint arbitral tribunal, arbitral institution, and that arbitral institution have the authority to appoint arbitrator for that particular dispute in that matter. Now the next topic is challenge of appointment on following grounds. If the party is not satisfied with the person to be as an arbitrator in that matter, so in that case the arbitrator shall challenge of appointment on following grounds. Let's see some grounds. First, not having an agreed qualification. If a person have not the agreed qualification as per the requirement, as per the agreement of the arbitrator, so in that case he will not be appointed as an arbitrator in that particular subject matter. It means if a matter related to a building contract, so in that case if the person have knowledge about regarding the topic, that matter, so he will only can appoint in that matter. Now second one is doubt on independency or impartiality. If a party thinks that a person is not be independent or impartial one, so he will not be appointed as an arbitrator for their subject matter. For example, past or present relationship. If the arbitrator has any relationship with any of the party, like in present or in future, so he will not be considered as an impartial arbitrator. Second, interest in any of the party. If the party have any personal interest with that arbitrator, so in that case arbitrator will not be appointed because he will not be an independent or impartial arbitrator for that particular proceeding. Financial interest. Financial interest is one of the most important factor, because in monetary terms, if the arbitrator is related with any of the party, so we can say that in that matter he will not be considered as properly independent or impartial arbitrator. The next topic is failure to act as an arbitrator. What if arbitrator appointed, but in between the proceeding he want to discontinue that proceeding, so in that case on following grounds his position will get terminated. First ground will be unable to perform its function. If the arbitrator is unable to perform its function, so in that case his position will get terminated and will discontinue to perform as an arbitrator in that particular proceeding. Second is failure to without any delay. It means if an arbitrator doing so much delay in that proceeding, so in that case the arbitrator position get terminated in that matter. Now third, withdrawal from office. Withdrawal from office, it means if an arbitrator willingly wants to discontinue that particular proceeding, so he can do so. Fourth, parties agree to terminate. If any of the parties, both the parties agree, desires that they don't want to continue with that particular arbitrator, so he can terminate the arbitrator position from to resolve their dispute in that particular arbitral proceeding. Now, what after termination? The topic is termination. That what if the arbitrator get terminated? Now, the parties shall have to appoint new arbitrators, which means the substitute arbitrator shall be appointed. Now, the substitute arbitrator, which means new arbitral tribunal, have the power, have their own discretion. They can maybe continue with that previous hearing or may start with the new hearing. So he totally depends on them that they want to continue with the previous hearing or start with the new one. So now, from now onwards, the presentation will going to give by my team member Isha.
Thank you, Aishwarya. Now, Arbitration Council of India. The Amendment of Arbitration and Conciliation Act 1996 in 2019 mandate the establishment of ACI, that is Arbitration Council of India. The Act authorized the central government to establish ACI as an independent government body. The council shall be a body corporate having the following features, namely perpetual succession, common seal, limited liability, or to acquire, hold and dispose of property including both movable and immovable. The main objective behind the formation of ACI is to promote and encourage arbitration, mediation and conciliation, and for that it frames the policies for grading arbitral institution and maintain the records of the award passed by the arbitrator. Now the composition and the tenure of the council. The council composition consists of the chairperson and other member. Now tenure. The chairperson shall hold office for a period of 3 years or until he has attained the age of 70 years, whichever is earlier, while the member shall hold office for a period of 3 years or until he has attained the age of 67 years, whichever is earlier. Now the resignation of the member. The chairperson and the member may resign from his office by making an application in writing to the central government, but such chairperson and the member shall hold office for a period of 3 months from the date of receipt of notice or until a new duly person has been appointed in his place. Now the topic is removal of the member. The central government is authorized by the Act to remove the member on the following grounds: if he is an undischarged involvent, convicted for an offence involving moral turpitude, abused his position which affect the public interest, and physically and mentally incapable to act as a member, and last, has acquired assistance financially which affect the public interest. Now the arbitral proceeding, it consists of 6 steps, namely, first is statement of claim and defense. In this, parties are required to submit their facts supporting with statement of claim and defense within an appropriate period of time. Next is hearing and written proceeding. The tribunal shall hold oral hearing. The tribunal shall hold oral hearing on the request of the parties, otherwise no such request made, then no oral hearing shall be conducted. Then default of the parties. In this, if the respondent fails to submit his statement of defense, or where the claimant fails to submit his statement of claim, or where both the parties default in appearance within an appropriate period of time, then the tribunal shall continue the proceeding and pass the arbitral award by considering the evidence present before him. Then an expert appointed by the arbitrator. In this, the arbitral institution may appoint one or more expert in certain circumstances in which they need it. Now, court assistance in taking evidence. In this, the parties with the prior approval of the institution may make an application in writing to the court for obtaining the evidence which they require regarding the proceeding. And the last is decision, which termed as award. The arbitrator shall pass the award considering the statement of facts and defense and other necessary evidence. Thank you. Now my next team member will continue from this.
Isha. So after the proceedings, the arbitrator shall give its decisions based on the facts of the case, which resolves the dispute between the parties, either wholly or in part. It is known as the arbitral award. It is a final judgment it is binding in the same way as a court order. It also includes an interim award. Now what's an interim award? An interim award is a temporary award which is given prior to the final award. So what can be the purpose of giving interim award? To appoint a guardian in case of minor, to preserve the goods if they are of perishable nature, to secure any amount of claim, or there can be any other relief as may be required. Now let's see an essentials of arbitral award. It should be in writing. It can be in any agreed language. It must follow the agreement. The decision should accompany with reasons. It must be certain. It should be properly dated and signed. What can be the time limit of award? The arbitrator shall give award within a period of 12 months from his appointment. However, parties with mutual consent file an application to the court. The court may extend the period for further 6 months if it deems fit. Additional award. What is an additional award? If the tribunal omits any fact of the case while presenting his award, then it has to pass an additional award. It is passed within the 30 days from the final award, for which parties have to file an application to the tribunal within a period of 60 days, after which the tribunal pass an additional award within a period of 60 days. Note, correction and interpretation of award may be made within 30 days from the award. Now what is this? There can be an error while giving the award. Error can be a major one like omission of decisions from the award, or a minor one like a spelling mistakes. So the correction has to be made within the award. It is made within a period of 30 days from the final award. Now, as we have discussed about the arbitration so far, let's see one of the recent case law based on the arbitration. Here the case name is NTPC Limited versus MS Deconer Services PVT Limited. Here the appellant is NTPC Limited and the respondent is MS Deconer Service PVT Limited. Now let's see the facts of the case. What was happened in that case? NTPC Limited issued 2 contracts, or we can say 2 tenders, for which both were allotted to the Deconer Service Limited on the condition that after the completion of first project, a rebate of 16% will be provided on the price. However, the NTPC Limited failed to deliver the land on time, for which there was delay in the construction on the site. The dispute arose between the party regarding the amount which was required to be payable to the respondent. Now what will the respondent do? Respondent invoked the arbitration clause which was mentioned in the agreement. The arbitration award was passed in favor of the respondent. Now the appellant made an appeal to Divisional Bench of High Court. Divisional Bench of High Court dismissed the application and imposed a cost of ₹10,000. Now further appeal was made to Supreme Court. Now let's see what was the question arise in the Supreme Court. Whether the respondent's appeal is allowed in the court, it was held no. What were the reasons? It was held by the Supreme Court that court has no power to intermediate between the arbitration award except if there is a misconduct by the arbitrator. So in conclusion, the arbitral award is binding upon the parties and no appeal lies against the award. To conclude, arbitration is one of the best additional alternative dispute mechanism one can opt for. Thanks.
Such an outstanding performance of Team 1. Now I would like to invite none other than team number 3 on the stage for presenting their presentation.
Good afternoon everyone. Myself Tanisha Gupta and I, in the behalf of my team, welcomes you. So, today we live in a world where exchange of goods and services happen for money. This money is in a form of particular currency. Say, India has rupees, USA has dollar and so on. But value of one currency is not same as that of another. So here the need of foreign exchange arises. Without it, it would be nearly impossible to determine the value of goods and services imported and exported between different countries. Without having the possibility to trade, companies which rely on overseas resources and talent would completely be crippled. And it will create major problems for the foreign travelers to buy and sell when abroad, thereby making foreign exchange management so important. So, So for this management, Government of India has enabled and enacted so many acts, one of which was FERA Act, which was introduced in 1973. FERA Act was introduced when foreign exchange reserves were too low. So it proceeded with the presumption that foreign exchange earned by the Indian citizens would belong to Government of India and certain activities are not permitted by RBI. So, but what happened? FERA Act fails to achieve its objective. So, FEMA came into existence on 1st of June 2000. FEMA Act extended certain activities permitting individuals and company to undertake foreign transactions. So, we can say that FEMA Act has assisted our country in managing the foreign exchange resources of our country. So, here is the difference between FERA and FEMA Act. FERA Act was introduced when foreign exchange reserves were too low, while FEMA was introduced when foreign exchange reserves were sufficient. FERA Act, the intention of FERA Act was conservation and protection of foreign exchange, but that of FEMA Act was to manage foreign exchange. So, for proceeding further, FERA Act was a rigid approach, whereas FEMA Act was a liberal approach. Any contravention in the FERA Act was a criminal offence and was punishable with imprisonment, but that of contravention of FEMA Act was termed as civil offence and punishable with imprisonment or fine or both. So, FEMA Act is applicable to whole of India. So, need an objective of FEMA Act. First of all, it consolidate and amend laws related to foreign exchange. Secondly, it facilitate external trades and payment. And third, promote the orderly development and manage the foreign market in India. So, now I hand over my spot to my teammate Adisha to further proceed with the presentation.
Already saw how, when and why FEMA came into existence. Now comes the structure of FEMA. Whenever an act is being implemented, it is being implemented in a framework that concludes several sections, subsections, regulations, sub-regulations, so as to make it more clear, specific and provisions and with provisions. Talking about FEMA, FEMA is being divided into 7 chapters, which are further being divided into certain sections. Each chapter containing certain sections for FEMA to be successful. Before going in detail with important sections, we need to categorize certain terms so as to make FEMA more clear, which includes PRI and PROI. For PRI, person resident in India, any person who is being residing in India for a period of more than 182 days in the last financial year will be categorized as a person resident in India. So for a person to be categorized as person resident in India for an offence made in August 2021, we need to analyze the financial year April 2020 to April 2021. Talking further about it comes the sections. For section number 1 and section number 2, it includes certain important terms, some definitions related to FEMA. Going on with section number 3, it prohibits dealing in foreign exchange but allows if authorized through an authorized person. So no person is allowed to deal or transfer or foreign exchange to any person or make payment to any person resident of outside India or receive any payment on behalf of person resident outside India, entering to any financial transactions in India or acquiring or creation or transfer of any right or acquisition of any asset outside India, but allowed only if it is permitted under the Act. So for any transactions related to these, we have to carry on the Act as well. Section 4 deals with prohibition on holding. If any person wants to hold any foreign exchange, foreign security or immovable property outside India, they need to carry the Act with it. So we need to analyze the Act and then make the accordance. Next comes the type of transactions. There are 2 types of transactions included in FEMA, which are current account transactions and capital account transactions. For current account transactions, these are the slides for person resident in India, person resident outside India. For current account transactions, section 5 includes dealing in current account transactions. Any person may sell or draw foreign exchange to or from an authorized person if such sale or drawal is allowed by CG. That is, that CG should not put them in restrictions. We will carry on the restriction a bit later, but before that the question arises, what is current account transactions? So according to section 2, it means transactions other than capital account transaction and includes payment due in connection with trade, business, short-term banking facility, payment due on interest on loan and net income from investment, remittance for living employees, parents, spouse, children residing in abroad, for traveling, education and Medicare. So all these transactions and related transactions to it are included in current account transactions. This section further details in restrictions of dealing in current account transactions, which are being further categorized in certain rules, which include rule number 3, rule number 4 and rule number 5, where rule number 3 decides the prohibited category, the rule 4 and 5 decides the restricted category. According to rule 3, the prohibition is made on drawal of foreign exchange if that drawal is to travel to Nepal and Bhutan or transaction with person of Nepal and Bhutan, where the prohibition may be exempted by RBI. This also includes transaction as specified in Schedule 1. Here is the list of transactions which are specified in Schedule 1. So if any person wants to do any activity in relation to the list as specified, they have to take, they are not allowed to do that because they are being prohibited by central government. Talking about rule 4, for rule 4, prior approval of central government is required. So for any transaction which is being specified in rule 4, they need prior approval of central government. This also includes the transactions which are specified in Schedule 2. So for any transactions specified here, the prior approval of CG is required. The next and the last rule is rule 5, which requires prior approval of RBI. So if any transactions related to the ones specified here will need prior approval of RBI. So if any individual wants facility with relation to this list, will have to take the prior approval of RBI. For capital account transaction, I'll hand over my spot to my next teammate Tanisha back again.
So, as we have seen Adisha explaining current account transaction, so I will proceed further with what is capital account transaction, which is defined in section 6 of FEMA Act. So, what is capital account transaction? Capital account transactions means any transaction which alter assets or liability, including contingent liability outside India of PRI or in India of PROI, and it includes all the transactions which are specified in section 6 subsection 3, which says RBI may by regulation prohibit, restrict any of the following, that is issue or transfer of foreign security by PRI, PROI or any office of PROI in India, or any borrowing or lending in rupees between PRI and PROI, or export, import, holding of currency, etc., or transfer of immovable property in India, outside India, other than lease of 5 years by PRI or PROI, or giving any guarantee or surety on the behalf of any person, say PRI which is owned by PROI and vice versa. So any person can buy or sell or draw foreign exchange to or from authorized person for further capital account transactions. But RBI has, in consultation with the central government, specified the classes of the capital account transactions and limit up to which capital account transaction can be admissible for such transactions. Schedule 1 talks about permittable capital account transaction by PRI, which include if PRI wants to make investment, he can make investment in foreign securities, or he can take loan in India or abroad, or he can acquire or transfer immovable property outside India, or he can give guarantee in the favor of PROI and so on. Whereas Schedule 2 talks about permittable capital account transaction by PROI. So if PROI wants to make investment in India, so he can invest in the securities which are issued by the Indian company, or he can directly contribute to the capital of firm or proprietary firm or association of person, or he can acquire or transfer immovable property in India, or he can give guarantee in favor of PRI and so on. So here is Garima Shekhawat, who will proceed further to explain capital account transaction in detail.
So till now we have discussed about the definition or some introduction part of capital account transaction. Now we are moving further on regulation 4 of capital account transaction, which says that no person shall undertake, sell or draw any foreign exchange from to or from authorized person for capital account transaction, provided, but there is a provision which says that a resident individual can draw foreign exchange from authorized person up to a specified limit, which is $250,000 per financial year for capital account transaction as specified in Schedule 1 of Regulation 3, which we have covered earlier. Now the next topic comes is modes of acquiring properties, which can be acquired in two different ways. First one is outside India, which is acquired by a person resident in India, and in India, which is acquired by a person resident outside India. The first of all, we are talking about the acquisition of immoral property outside India by person resident in India, which he can acquire in following ways. First one is inheritance or gift from these three types of person. First one is a person who is now a person resident in India but was a person resident outside India when he acquired such immoral property or has inherited from a person resident outside India. Second one is a person who has acquired on or before 8 July 1947 and has continued to hold that property with RBI's permission. Then third one is who has acquired property with foreign exchange provisions in force at time when he acquired such property. Second one is purchase. So by way of purchase, he can also acquire immovable property from foreign exchange which are held in his or her resident foreign currency account. Third one is joint ownership. So he can also acquire with his relative as a joint ownership, but there is a provision which says that no outflow of cash should be there from India. Fourth one is companies having overseas office. Companies which are having overseas office can also acquire immoral property for any business purpose or residential purpose for its staff. But there are some limits which has to be complied with. First one is initial expenses. The initial expenses should be 15% of average annual sales or turnover or income during last 2 financial years, or 50 or 25% of net worth. From these two limits, whichever is higher should be considered. Then second one is recurring expenses. Recurring expenses should be 10% of average annual sales or income or turnover during last 2 financial year, which has been covered here. Now the second one is by acquiring property in India by person resident outside India. He can also acquire any property and help to acquire that property when he was now he is a person resident outside India but was a person resident in India when he acquired such immovable property or inherited from a person resident in India. Now the next topic comes is acquisition and transfer of property in India can also be done by these following parties. First one is non-resident Indian. He can acquire any immovable property but other than agricultural land, plantation property or farmhouse. He can transfer any immovable property to a person resident in India. He can transfer to a person resident outside India but is a citizen of India, means a non-resident Indian or a person of Indian origin. Here person of Indian origin means a person who is a citizen of any other country but other than Bangladesh or Pakistan, who at any time is holding a Indian passport. Now the second one is by person of Indian origin. He can also acquire any more property but other than agricultural land, plantation property or farmhouse. Can acquire by way of inheritance from a person resident in India, a person resident outside India, a non-resident Indian or a person of Indian origin. He can transfer any property by way of sale to a person resident in India, can also transfer agricultural land, plantation property or farmhouse by way of sale or gift to any person of Indian origin or a non-resident Indian. And fifth one is transfer of residential or commercial property property by way of gift to a person resident in India, non-resident Indian, or a person of Indian origin. So these were the categories which were covered under the person of Indian origin. Now the third one is for carrying permitted activities. So this is covered under Regulation 5 of Capital Account Transaction. A person resident outside India who has established in India any branch, office, or any other place for carrying out these permitted activities in India can acquire any immovable property for these purposes. But this has an exclusion which excludes liaison office. A liaison office is a place of business which acts as a channel of communication between the parent company, which is outside India, and its business units which are established in India. But however, all applicable laws, rules, regulations, or directions should be complied with, and the person files with RBI a declaration in form IPI within 90 days from the date of such acquisition. The person resident outside India can also transfer these properties, this property by way of mortgage to authorized dealer as a security for any borrowing. Then fourth one is by foreign embassies, diplomats, or consulate generals. So these following entities or parties can also acquire immovable property in India, can purchase or sell immovable property but other than agricultural land, plantation property, or farmhouse in India, provided clearance from Government of India and Ministry of External Affairs should be obtained for such purchase or sale. But the amount of repatriation does not exceed the following given limits, which is amount paid for acquisition of immovable property in foreign exchange received through a normal banking channel, or funds which are held in foreign currency non-resident account, or a foreign currency equivalent to amount paid where such payment was made from funds held in non-resident external account for the acquisition of property. Now the next point comes is in case if there is a residential property, so then the repatriation of sale proceeds should be restricted to not more than 2 such properties. Now I am handing over the next for the further presentation to Rohit.
Now moving forward, we have authorized person, which is covered under section 10 and 12 of FEMA Act 1999. Authorized person means any person who is authorized to deal in foreign exchange, which includes authorized dealer, money changer, offshore banking unit, or any other person authorized to deal in foreign exchange or foreign securities. Now the duties of authorized persons are to comply with RBI direction, not to engage in any unauthorized transaction, ensure compliances of FEMA provisions, and to produce books of accounts, etc. Now we have powers of authorized person. An authorized person has to deal in or transfer any foreign exchange, to receive payments by order, to sell or purchase foreign exchange for current account transaction and permissible capital account transaction. Now moving forward, we have contravention and penalties. It is covered in section 13, section 14 and section 15. Section 13 states that any amount of contravention, section 13 categorize the penalty into some points. First point is that if the amount is quantifiable, then the penalty will be thrice of sum involved in the contravention. Where the amount cannot be quantifiable, the penalty may be imposed up to 2 lakh rupees, and if the contravention is continuing every day, then the 5,000 rupees for every day after the first day during which the contravention continues will be imposed as penalty. Now we have section 14, which states that if any person fails to pay the penalty amount within the period of 19 days, he shall be liable for civil imprisonment. Now moving forward, we have section 15, which states that Directorate of Enforcement is empowers and other officers of RBI as may be authorized by central government to compound the offences. Moving forward, we have adjudication and appeal, which is covered under section 16 to section 35 of FEMA Act 1999. Section 16 states that central government is empowered to appoint any adjudicating authority. Section 17 states that Section 17 states that any person who is aggrieved by the decision of adjudicating authority have a right to make appeal to special director who shall be appointed with the provisions of section 17. Now, if any person is aggrieved by the decision of special director, he has a right to go to the appellate tribunal under section 18 of FEMA Act, and if any person is aggrieved by the decision of appellate tribunal, he has a right to make an application to High Court within 16 days of the decision passed by appellate tribunal. Now, moving forward, we have Directorate of Enforcement, which is covered under section 36, 37 and 38, which states that the central government shall establish a Directorate of Enforcement with the director of such other officers such as police officers, central excise officers and so on, as it thinks fit, who shall be called officers of enforcement. They are conferred with the powers relating to the income tax authorities, such as powers of investigation, search and seizure. Now, the last section of this topic is we have section 37 subsection A, which states special provision relating to the asset held outside India in contravention of section 4. Now, I am giving the mic to my fellow mate.
Now, continuing with the next topic is compounding and contravention. Before going in detail with this topic, we must know about the difference between compounding and contravention. Compounding refers to a voluntary procedure of admitting the contravention, pleading guilty and seeking redressal for it. Contravention, whereas it means violation of any rules, regulations, orders and notifications. Now, what does the compounding of contravention here means? It is basically a simple way to avoid litigation. FEMA laws provide an option whereby a person can voluntarily accept the contravention and apply for the compounding of the contravention and seeking redressal without going through a lengthy procedure of litigation. It is a voluntary procedure in which individual or a corporate seeks a compounding of admitted contravention. Now, the procedure here followed for the compounding of contravention is the application is submitted by a person and a company with the prescribed fee of rupees 5,000 by the way of demand draft in the favor of RBI and paid to the concerned regional authorities. This application is examined on the basis of documents submitted with it, and it is assessed whether the contravention is compoundable or not. The order is passed within 180 days from the date of admission of an application, and also the compounding authority, if they think fit or if they require, may ask for the additional information too. Now, the various factors of compounding are unfair gain, loss of agency authority, economic benefits, whether contravenor is suo motu approach the RBI, and history of non-compliance. Now, moving forward with the next topic, prerequisites of compounding of a contravention. No compounding is done if the appeal is filed with a special director or an appellate tribunal. Also, a contravention of a similar nature is not compoundable within a period of 3 years where such similar contravention has been compounded earlier. Also, a contravention in respect to any transaction where any permission or approval is required from any government or authorities, such contravention is not compoundable unless approvals have been obtained from such concerned authorities. Now, I'll conclude the whole PPT. FEMA replaced FEMA. It was not just a piece of paper. It was in terms of inflows and outflows of foreign exchange. FEMA was only the regulation where FEMA works for the proper management of foreign exchange. Under FERA, all the violations would attract prosecutions, whereas in FEMA, it was diluted with the rigorous enforcement provisions which were hallmark of the erstwhile legislation. Violation of FERA was a criminal offence, whereas violation in FEMA, it was a civil offence. I am of the view that FERA has rightly replaced FERA as to boost the Indian economy, and with the growth of nation's economy, it is becoming more important. Thus the government is updating FEMA with the change of the requirements according to the economy. Thank you for your patience attention.
I would like to thank all the team members for participating so well. So there must be a big round of applause for you all. Very well done. At least you all guys participated. That is the important thing. You learned something new. That is very, very important. Whatever the stage is there, you must always participate in such kind of activities. So you will find yourself that you have developed certain skills in yourself, and I hope so ki you have developed certain skills in these 4 or 5 days when you participated, when you coordinated, when you prepared PPT, and even when you presented over here. I really wish ki entire students would have been participated over here and have come to this stage. So finally, it's a time to disclose the results. What do you think? Who is going to be winner? Let's don't create the suspense. I would like to invite our judge, Chinmay sir, on the stage to declare the result.
The performance of each and every student were awesome, unbelievable. और देख के लग ही नहीं रहा था कि ये स्टूडेंट्स आके यहाँ पे प्रेजेंट कर रहे हैं. उनका पीपीटी, उनका कलर कॉम्बिनेशंस, उनका बोलने का तरीका, दैट वाज वेरी प्रोफेशनल. एंड जो हम लोगों का जो मेन पर्पस है कि स्टूडेंट्स आके अपना कॉन्फिडेंस बूस्ट करें, मुझे लगता है ज़रूरत ही नहीं है, ऑलरेडी है, लेकिन इतनी दिनों की प्रैक्टिस है तुम लोगों की. तो डेफिनेटली यू परफॉर्म्ड well and superb. So first, a great round of applause for each and every student performance. किसी भी कंपटीशन के अंदर ये डिसाइड करना मजबूरी होता है जज के लिए कि किसको फर्स्ट देना और किसको सेकंड, तो वो तो ये फॉर्मेलिटी में करनी होगी, लेकिन एवरी इंडिविजुअल परफॉर्मेंस इज सुपर. 1 और 2 परफॉर्मेंसेस थोड़ा इंप्रूवमेंट का जरूरत आप बोल सकते हो, क्योंकि मैं हर चीज मेंशन करूंगा. तो 1-2 में था कि वो फेस पे लग रहा था कि डरा हुआ है बंदा, डरी हुई है, जो भी है क्लियर ही नहीं, लेकिन यस ओवरऑल यदि आई से अल्टीमेट सुपर. तो फर्स्ट एंड सेकंड एंड थर्ड इज ओनली ए फॉर्मेलिटी, वो फॉर्मेलिटी करनी होती है, लेकिन सारी परफॉर्मेंसेस बहुत बढ़िया और जो पर्पस था वो फुलफिल हुआ. तो तुम लोगों का ज्यादा टाइम कंज्यूम किए बिना, क्योंकि अभी तुम चाहते हो सर ना कुछ बोलो, अभी डायरेक्टली बता दो वो इज अ विनर, क्योंकि हमें पता है, हमने देख लिया है कि कौन विनर है. और शायद तुम लोगों को आइडिया भी लग रहा होगा, क्योंकि बहुत सारे फैक्टर्स थे जिनके आधार पे हमें ये कहना था कि हु इज अ फर्स्ट विनर. मैं क्राइटेरिया एक बार अनाउंस कर देता हूं. नंबर 1 इज अ कम्युनिकेशन, आपका वे क्या था, एंड कोऑर्डिनेशन बिटवीन द टीम मेंबर्स एंड द ड्रेस कोड एंड द टाइम. 20 minutes were allotted and some members have taken 40-45 minutes. This is also a very important criteria. Project content और प्रोजेक्ट को आपने कैसे प्रेजेंट किया, जो कलर कॉम्बिनेशन, इमेजेस और जो भी आपने डिस्प्ले किया, ऑल द फैक्टर्स जो यहाँ पे आपको सोनम मैम ने पहले ही बता दिया था. और सोनम मैम के लिए भी थैंक यू, उनका इतने बढ़िया आइडियाज कहाँ से आते हैं कि बच्चों की स्किल्स डेवलप करने के लिए. उनको भी थैंक यू एंड कॉन्ग्रेचुलेशंस कि वो बच्चों की स्किल डेवलप करने के लिए कुछ ना कुछ करती रहती है. सुपर. तो ना सर मत बोलो कुछ. क्या होता है, जो मेन चीज होती है उसको बोलने से पहले सारी बातें बोल दो, उसकी बात तो कोई सुनेगा ही नहीं ना. तो डायरेक्टली आई अनाउंस अ विनर, द टीम 1. So winner team 1.
I felicitate all the team members of team 1. I would request Chinmay sir award them for their excellence. I would like to invite Ronak on this stage first. Then Arohi. Aishwarya, Isha, and Saloni.